Just making sure everything unmutes. Can't have a Monday on a Tuesday. That would be ridiculous. Bri, thanks for dropping by and with your thumbs up. And I hope you get a nap because working at 11 sounds awful. But I hope you have a good night and an easy night. Which I know is not easy in your profession or this time of year. Hey, Laura in Michigan, good to see you. Hey, Gabby, hey. Is that how you said that? Oh, my goodness. I'm hoping that it's raining and thundering, so I'm hoping it just goes on by. But Gabby, I'm pretty sure that you can that you have access, that you can just come in here should my power go out. I need you to shut the stream down. See, I knew that's how you said it. Oh my goodness. Whew. So, what'd y'all do today? No Karen Reed. Did you guys like go outside and get some fresh air? Like, what'd you do? I was with my dad, and Bree brought Mad Dog over to see him and to see me. So I saw them today, had lunch with them, and got some fresh air because I had to go outside to leave my house and to come home. But it was fun to see all the theories of why Karen Reed was not in court today. Some of them I kind of wished were true. Others were hilarious. It sounds like somebody is sick. I don't know who. Doesn't matter. I'm sure they will be back tomorrow. But I don't know. You'd have to look that up before going in and shutting it down. It's super easy. You hit end stream and then it's done. The only thing you won't be able to do is go over to Rumble and end that stream. So hopefully we will not have that problem and it will not happen. So it has happened one time. And fortunately, it was not very long of an outage, but you all just sat and chatted, and then I came back. I texted Gabby and said, my power just went out. I'll be back in a minute. Oh, I see what you're saying. I don't know. I'll send you a link. I think we'll be okay. I almost hit leave studio. But I'll send you a link, even though it kind of seems to, I think it's going to go around us. My poor husband was going to go outside and and mow. And he texted me, he's like, I didn't even get out there. Like, sorry, because our grass is growing like crazy because it's been cold. It's been like cool mornings and rain and sunshine. And it has been perfect grass growing weather. All right, Gabby. There it is. It has been sent. And now back to the show. Okay. Yes. I agree, Laura. Thunder gods, leave me alone. Yes, I see what you mean. We'll have to test that out one day, Gabby. There is a way to do it. We'll have to figure it out. But not today. That's fine. We've got about an hour's worth. Ooh, that was a big one. We got about an hour's worth of testimony today to get through. This is Daniel Jaffe. It's Jaffe. Not sure if I'm saying that name right. He is the Beverly Hills divorce attorney that I believe was Betty's original divorce attorney on her in her divorce. What I was reading today, it seems like, I'm sure he'll probably talk about it in his testimony, But it seems like he had thought that he had reached a settlement agreement with Dan Broderick's attorneys about the sale of the home. He was going to give her, 50%. He was going to give her an extra, I can't remember how much it was, $40,000 or something like that on top of the sale, whatever the proceeds of the home were. And so Mr. Jaffe or Jaff or whatever it is, him and Daniel Broderick's lawyer, they sign everything, like they draw up everything, they take it to Betty, and Betty's like, nope. So from my understanding from the article I was reading, communication basically ceased between the two. He, it said that he eventually, wasn't her attorney anymore. But then as I read a little bit further, it talks about how he kind of was back. So I don't know. I read another little interesting blurb. It was Betty telling her own, version. And she said, kind of like we have said about her getting $16,000 a month in alimony payments, and how can you not survive on that? Well, she explained. I was like, well, okay then. Hey, Ronnie, how you doing? Good to see you. So, she said, I know a lot of people think like $16,000 a month. What am I complaining about? Yep. Then she was talking about her mortgage. Understood. She lost me at clothing because she was like, she basically was saying she was used to dressing in, you know, clothes that cost, the outfit cost $2,000. I'm like, then you don't buy clothes that cost $2,000 anymore. Like, it's just, you have to adjust your life. That's just what you do. We all have to do it. We all adjust up, we all adjust down. Just how it goes. That is life. And so she lost me there. I didn't read anymore because I was like, oh dear woman. It's just, so apparently she spent, because she wouldn't stop saying bad words, she spent many days in jail. She had to pay thousands of dollars in fines, which also I'm like, okay, so is that eating away at your 16 grand a month because you can't shut your mouth? It just, she's her own worst enemy. And she doesn't see it. And that's really sad. And I get the, the side of like Dan was driving her crazy and Dan pushed her over the edge. I understand that side of things. But we have not heard from the defense one reason yet she needed to unalive both of them. Not one. They've not touched on it. They've just said, poor Betty. So, I don't know. I was trying to think one other thing that I read about her. And these are from old articles from that time, from the time span of this trial. It's just interesting to kind of go back and look at things. But I don't know. Hey, Christine, how you doing? It is good to see you. I hope everything is going well for you. So I think that's about it. I think that's about all I have for you right now regarding that. I probably should have explained the trial that we're watching for anybody that's here for the first time. This is the Betty Broderick trial from 1991. She is it took place in California. She is on trial for allegedly unaliving her ex-husband, his new wife, Linda. They'd been married 6 months. I always say Linda was the newer, prettier model because Linda was 21 when Dan met her, when he hired her as a secretary for his law firm. He and Linda, or him and Betty, were pushing their late 30s, they weren't quite 40 yet. So big age difference. I'm not saying anything's wrong with that. She was of legal age, so whatever. But Betty didn't take it well. And that's the other thing that she told this attorney that we're going to see, that the reason that she didn't want to take that settlement agreement is because she wanted to reconcile with Dan, and she thought they could. So I don't know. And maybe she really did want to reconcile with him. Maybe she really did think they could. I think she thought he was just going to come running back to her, but he didn't have to. And he was well on his way to not having to. They weren't married yet at that time, but him and Linda, I would say, were together. Whether it was, Facebook official. I know there wasn't Facebook at that time, but if it's not on Facebook, it's not official, right? I don't know how I feel about the daughter, Ronnie, because she went through a lot at a young age. I don't know. I cannot imagine testifying against my mother because she unalived my father. Like, I don't know what I would do just for the relationship that my parents had and the relationship I have had with them. But I know not everybody has a good relationship with their parents. So I don't know what I would do. And I think, hey, I don't even have Facebook, Baker. Just I have Twitter, and I never even post on there. What you do all day, Baker? I probably am his elder. Dang it. Man, reality hits you. It's like, hey, don't make fun of Tom. Was that his name? Tom on MySpace, that was everybody's first friend. Don't make fun of him. He's a cool dude. Wonder where he's at. Like, that's old Tom. Was it Tom? I think it was Tom. He had that weird picture of himself. One thing, if the weather holds out and I don't lose power, that I want to show you at the end of this, it has nothing to do with this trial whatsoever, but I saw it today and I think it's weird. You're 27. Well, I'm 25. So I have yet to explain my child, one being 30 and the other being 32, and having a granddaughter. But hey, life. 27 in French. So I saw today where at this trial in Arizona, it was a road rage incident where a man was unalived by the other man. And in court, the family of the victim made an AI victim. Like, they made him an AI, and they were able to present the victim, who is not here anymore, they were able to present his victim impact statement in court using AI. And I watched a couple minutes of it. It was weird. I'm not sure how I feel about it. And I don't have any legal training or school or anything like that. But legally, it seems very strange that would be allowed. I see a lot of challenges probably coming up if that trend continues. But it's just very strange. Now, they played the AI version, and then they played a real him in video, like the real guy, and then came back and said, "See, that's me. You can hear that that's me." But I thought, but he didn't tell AI what to say, right? He didn't get to write his own victim impact statement because he's dead. So it wasn't his words necessarily, unless I just really don't know how AI works, which is possible because AI kind of freaks me out a little bit, to be honest with you. So And that's what I was kind of thinking, Baker. Like, it's not him. It's not his statement. And as I was reading that, the judge, so they were asking for 9.5 years, and the judge gave the guy 10 and a half years, and went back and said that that guy's victim impact statement impacted him. Like, it influenced him. And I thought that's just seems not right. Like, I don't know. The person, the anchor that's doing it on Court TV, she's not my favorite. So I didn't listen to all of her. She probably has some weird take on it at the end. She made some kind of statement one time about guilty people go to jury trials, innocent people go in front of the bench, or something dumb. Like, I was like, you are just so wrong, lady. You shouldn't be in a courtroom anywhere. AI freaks me out. Terminator was just a movie. Sure. Did you see the video of the robot that was trying to attack the person in the lab? And the only reason he didn't get to attack the person was because the robot was still tethered. Yeah, it's coming. It's coming. There's going to be an uprising of freaking robots, because we cannot just not have robots. They're just weird. It's wrong. It's all wrong. I don't know. I don't know what to do about it. I'm kind of hoping maybe, since I am an old, that I'll be gone by the time they are really roaming the streets. Not, just here and there. And those robot dogs that they use for police, they're weird. They don't have a head. It gets weird. He had it coming. I can't help you. I can't help you with your Smex AI robot. Well, Jetson's like hairdoer machine. Remember the Jetsons, man? It's weird to watch that now. Like, we have all that thing. We have almost all that stuff now, except for I don't want the food replicator, because Star Trek told me that didn't taste the same as real food. So I just want real food. I don't want that, but I would take Rosie the robot, I guess. She was nice. But even she went nuts. Right? Yeah, and that Jane didn't even know she had it made. Except she lived in space. So I don't want to live there either. But okay. Let's go do this, shall we? Babbled on long enough. Yes, Rosie was sassy. But Mr. Jetson deserved it every once in a while. Mr. Jetson was kind of a beat down man. They should have been nicer to him. He's got a horrible boss. He's got a bratty teenage daughter. His son was nice. And let's face it, the dog was awesome, because it was, pretty much like a Great Dane. Sorry, my fan's blowing my hair. That's it. All right, I've got this boosted, turned up. Let me know how the sound is. And of course, we don't have closed captioning again, because why would we?
And I understand that the people want to call a witness out of order at this time. And the defense has no objection to that. At this time, we're going to interrupt the cross-examination of Miss Kim Broderick, and the people are going to call Mr. Jaffe out of order. He has a scheduling problem, and he's only available to us this afternoon. Raise your right hand and be sworn, sir.
You do solemnly swear the testimony about to give in the matter not pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you please have a seat? And could you please state your full name for the record and spell your last name?
Daniel, initial J, Jaffe, Jaffe.
Thank you, sir.
Mr. Jaffe, how do you make your living?
I'm a lawyer.
What kind of lawyer?
I'm a family lawyer.
What is being a family lawyer, what does that consist of primarily?
Practice is exclusively divorce work.
Are you local here in town?
No, I'm from Beverly Hills.
And can you tell us a little bit about your practice, how long you've been involved in that practice and what sort of work you do?
I've been a lawyer since 1962. I've practiced family law exclusively since 1967. We have a 8-lawyer firm at the present time. The whole firm handles only family law matters.
Are you fairly well known as a family law practitioner in the Los Angeles, Southern California, and indeed the whole state of California?
Yes, I believe so. I'm very active in most local, state, and national family law organizations.
Calling your attention back to October of 1985, did you undertake representation of the defendant in this matter?
There was a retainer agreement signed in October of 1985.
And for the record, the person that you represented or had the retainer agreement with, is she present in court today?
Yes, it was Betty Broderick.
She's the lady seated at the council table to the extreme, as you sit the left-hand side
far
of the
left.
courtroom?
Yes.
May the record so reflect, Your Honor?
Record may reflect as identified the defendant, yes.
Thank you. In October of 85, after that day, did you then enter into the negotiation with Dan Broderick's attorney, Thomas Ashworth, for the sale of the family residence at Coral Reef?
Yes, that occurred in January of 1986.
And in that month, did you come down to San Diego for purposes of negotiating the sale price with Daniel Broderick and his lawyer, Thomas Ashworth, on the defendant's behalf?
Not necessarily the sales price of the residence, but how the monies from the sale of the residence would be divided between Mr. and Mrs. Broderick.
Tell us how that was accomplished, to the extent that it was.
I had written to Mr. Ashworth, I think at the end of 1985. Ms. Broderick had some concerns in the issue of, there was a buyer for the house at that point. Ms. Broderick had some concerns that when Dan Broderick had occupied the residence, I think after she vacated it, that certain things were done to the residence by Mr. Broderick in terms of decorating and landscaping and all, which he thought depreciated the value of the residence. And she wanted additional monies out of the residence when it's sold.
Normally, when a family residence such as Coral Reef is sold, what is the split between the husband and the wife who are divorcing? Professional witness, Your Honor.
Overruled, you can answer that.
If all of the assets are going to be divided equally under California community property law, if it was community property is to be divided exactly equally. But sometimes one party gets the house and the other party will get something of equal value. So there's no tried and true formula.
But in terms of the money that comes out of the house, is it fair to say, since it's a community asset, that each party will share equally in that amount?
Yes, but we may not divide those exact dollars.
That would be because certain monies might be offset against other expenses, that sort of thing?
Yes, other expenses or other assets.
But in terms of the ultimate value received by each party, the husband and the wife, be it in cash in hand or offsets against other things they may owe the other spouse, would it be an equal split from the sale price?
Yes, if it's community property, each party is entitled to 1/2 of the property.
Did you meet with Mr. Ashworth at his office to negotiate this particular sale?
Yes,
Did the defendant come with you?
she did.
You flew down from Beverly Hills to accomplish this?
Yes. Betty, she picked me up
At
at
the
the
airport?
airport, yes.
And what was the plan in terms of people present at the negotiation? Who was going to be there?
Well, we had originally planned for a 4-way meeting between Mr. Ashworth, myself, and the Brodericks
At Mr. Ashworth's office?
at Mr. Ashworth's office.
When you and the defendant arrived at Mr. Ashworth's office, what took place?
Well, she did not want to come up and attend the meeting. So she, I think, had a a truck or a van or a similar type of vehicle. She sat out in front of Mr. Ashworth's office in the car.
Did the defendant say why she wanted to do that?
She didn't want to be in Mr. Broderick's presence.
Did you then go up to Attorney Ashworth's office and negotiate a division of the sale proceeds on the defendant's behalf?
Yes.
Tell us how that came about.
No objection. Hearsay.
Sustained. Let's
rephrase it.
Did you go up and enter into a negotiation for the split sale price of Coral Reef with Attorney Ashworth and Dan Broderick?
I did.
And did you reach an agreement?
Yes.
What was that agreement?
The agreement was that the house would be sold. The proceeds would be equally divided between Mr. and Mrs. Broderick, but from Mr. Broderick's share of the proceeds, Mrs. Broderick would get an additional I think it was $18,500. And of that $18,500, $7,500 of that was an admission by Dan Broderick, so to speak, that she was entitled to that amount of money. And the additional $11,500 was going to remain open for further determination in the court proceeding or settlement. But she was to get 1/2 plus 18,500.
Oops, so not 40. I don't know where 40,000 came into play. Probably something I read. 18,000. It's the same. Maybe I was thinking today's money or something. I don't know. No, that'd be reversed. Never mind.
Is that a rather unusual set of circumstances in the sale of a family asset like this?
Your Honor, objection. Sustained.
Did you take that agreement down to the defendant as she sat in her Suburban?
Yes, I had gone up and down to her, to the office a couple of times, as I recall, bringing back her desires to the negotiation table. And I thought we had an agreement. Mr. Ashworth's office, before I left, had typed up an agreement. I signed it. Mr. Ashworth signed it. I don't know if Mr. Broderick had signed it at that time. And I brought that agreement down to Mrs. Broderick for signature.
Did you tell the defendant that all the other parties were agreeing to this particular arrangement, that she would get half plus $18,500 out of Daniel's 1/2 share?
Yes.
And was this an amount the defendant had earlier told you that she wanted?
It was close.
How close?
I think her original claim was for half of $41,000 or $42,000.
And what does that translate?
There was, as I just looked at the correspondence, there was a claim that Mr. Broderick had put $40,000 or $42,000 into the house of community funds or insurance proceeds and community funds, which Mrs. Broderick did not think benefited the property by that amount. And that was the whole purpose of the unequal division. It was due to her claim that Mr. Broderick had improperly used the community funds on the house. And if they were community funds, they were improperly used. And assuming that were the fact that they were improperly used, then he used up half of her $40,000 or $42,000 improperly. So she'd be entitled to that $20,000 or $21,000 back. And we got 18,500 of that amount.
So we're talking about $2,500 difference between what she wanted and what you had ultimately been able to negotiate for her.
Close.
And when you came back with this agreed upon amount from the other parties, what did the defendant tell you?
Well, she wanted to think about it. She wasn't ready to sign it at that point.
What happened next?
I advised her that because this is the type of asset, nobody was going to be living in the residence, that it was just subject to depreciation, that Mr. Ashworth had advised me that unless there was an agreement, that he would go into court and get a court order to sell. I forgot the address, the name of the property.
5555 Coral Reef.
The Coral Reef property. And advised Betty that would be the probable result of this type of an asset if she didn't go along with this division.
Did you tell the defendant why Mr. Asher would be entitled to go into the court and get this sale order to sell Coral Reef?
Yes.
What did you tell him?
That Mr. Broderick had bought another residence and was about, or had vacated or was about to vacate the Coral Reef residence. That she had a new residence, and this was the former family residence. It was just going to be standing empty. And this is the type of thing that there's no reason to pay mortgage payments and upkeep and maintenance on these kind of assets, and empty houses are problems. That a court would likely treat this as a depreciating type asset and order the property sold as long as no one was living in it.
So you told the defendant essentially that Dan and his lawyer would be entitled to sell the house.
Yes, and that they were going to so move because that's what they advised me.
In the course of your professional practice, have you seen this done before many times?
Not often, but it's certainly done with an asset that there's no reason not to sell.
Can you tell us whether or not Attorney Ashworth and Daniel Broderick were cooperative and reasonable in the negotiations with you on this particular sale price?
Your Honor, objection irrelevant.
Overruled. You answer that.
I thought very much so. They didn't want to fight over the issue. They reserved the fight of the $11,000 to a later date, but they were willing to give the monies out at this time.
So the defendant would have gotten that money as soon as the house was sold.
Yes.
After the defendant told you that you wanted to wait a while, what happened then?
I gave her my advice. She took me back to the airport. I went back to Los Angeles.
And your advice was essentially to accept the offer
Sign it.
as reasonable?
Yes.
Did the defendant ever get back to you after she drove you to the airport about either accepting or outrightly rejecting the offer that was extended?
No.
Calling your attention now to February 4th, 1989, the attorney Tom Ashworth called you at approximately 10 a.m. on that day about the anticipated court order sale of the Coral Reef residence.
I don't have any independent recollection of that other than the declaration he filed.
And
I don't recall.
would you, there is a declaration though that you reviewed that says that he did do that.
Yes.
If, would you have any reason to dispute the accuracy of that
Your Honor,
declaration?
objection calls for complete speculation.
Sustained.
Do you have any recollection that you did not receive a phone call?
No.
Assuming that you were told that the house was going to be sold pursuant to a court order, would you have come down?
No.
Why not?
The objection calls for conclusion of speculation.
Overruled.
Because there was just really no reason to waste anybody's time or money. I thought it was an appropriate order. I thought we had a reasonable deal, and there was no reason to turn it around and then come down and oppose the deal that I had made a few days before.
And that is, you advised the defendant that Daniel Broderick was entitled to sell the house at that time pursuant to a court order.
If the court so ordered.
Do you recall during the time that you had contact with the defendant ever advising her in the area of child custody?
Yes, early on.
What did you advise the defendant?
Well, at that point,
Objection irrelevant.
Your Honor, I believe that there.
Sustained at this point. Go ahead. You believe what?
Well, maybe we need a brief sidebar at this point, Your Honor.
Was this an anticipation?
Yes.
Anticipation of something she might say?
Or has said in the past it would be admissible as an initial party opponent.
You wanted him subject to a motion to strike later, Mr. Early?
Well, I would just object to it at this time, Your Honor.
At this time, sustained.
Well, may I ask it subject to a motion to strike if the other evidence is not forthcoming? To avoid calling the witness back down.
Well, there's been objections as to others. It appears the witness is going to have to come down anyways.
I don't, no, that, and this is a rather peripheral area anyway, Mr. Burkhoff, so no, I won't allow you to do that.
Thank you, Your Honor. I have no further questions.
Cross.
Mr. Jaffe, you went in and you've talked about that while some assets you divided property in half, there's times that you don't divide it in half right upon the sale. Isn't that correct?
Yes.
Okay. And sometimes that's, and you don't always do that as an attorney, do you? Just say, you want to sell an asset, we'll take half and you'll take half?
Sometimes yes, sometimes no,
Depends on the case, is that correct?
of course.
And obviously, if you have a case where somebody might have assets hidden all over the case, all over the land, that might make it so you'd be a little leery about selling one asset that had both names on it, wouldn't it?
Objection, since that's not in evidence.
No, sustain, just rephrase it.
Okay. Well, sir, in this case, were you aware that this was the only asset, family asset, that was in the name of both parties?
If my involvement in the case, as long as I was involved in the case, I did not have a complete picture of what the community estate was, nor did I ever develop a complete understanding because of
Did you ever?
because of the way I was in the case.
Yeah. Well, did you ever talk to Mrs. Broderick about fears she had about assets that were being transferred to Larry Broderick before the divorce?
Yes.
You're standing relevant.
Overruled, answer stand.
And obviously, were you aware that through community assets that Mr. Broderick had brought Linda Kolkena while they were living together a condominium?
Objection, I'll prove that. It's beyond the scope of this witness.
Sustain.
Well, at the time that you were going there saying that this was a reasonable thing to do, did you know that at that point in time that there was a 40 acres in Telluride that Mrs. Broderick's name was not on?
I
Objection,
don't,
unless, excuse me, objection unless it had something to do with the negotiation of the sale of this particular piece of property.
Sustain.
Your Honor, may I be heard on that? May I?
No, just that he didn't know about that. He told you that already.
Well, he testified as an expert as you let him ask the question over what's reasonable and not.
It's reasonable as to the sale of that piece of property. You can ask him questions about the sale of a piece of property.
To know what is reasonable about a sale of a piece of property it would help you as an attorney to know whether there were other assets that may be hidden. Isn't that correct?
I don't know what the relevance of that would be.
Well, obviously, when people have a number of assets and very few of them have their names on it, would you normally have a concern about selling the one asset with the name, with your client's name on it, without addressing the others?
Objection, irrelevant.
Overruled, you can answer that.
The issue would be, what would happen with Dan Broderick's half of the equity less the 18.5?
Was all the money going to go into trust under your agreement, or were they each going to take their half?
They were going to take their half with Mrs. Broderick getting the additional 18.5.
Did Ms. Broderick talk to you about renting that house? Or do you recall that conversation?
I don't recall the issue of the money coming out. She needed the money to fix up the house that she was in, and that's primarily where we were going, and what the money we were looking for to help her with her new house.
Do you remember talking at all about whether the house could be rented or rather?
I don't recall that at all.
Did you ever discuss whether the rents would cover the mortgage payments?
I don't recall that.
The time that you indicated that the house could be sold in a court order, what did you tell her about a court order? Did you tell her that they could go into court and get the house sold?
On an appropriate showing that this was a depreciating or a wasting asset, that they could go into court and get such an order.
Okay. You didn't go into the details of how that court order, or what would happen in court, other than the fact on a proper showing, did you?
No,
You didn't use the term a liar, did you?
no,
You didn't tell her there would be a 4-hour notice, did you?
no,
You didn't tell her that you wouldn't come down for that 4-hour notice, did you?
no,
You didn't tell her that if they could leave, you weren't retained, were you? On the case at that time, I mean, you hadn't received any money.
I hadn't received any money.
And you let Mr. Ashworth know that you hadn't received any money, and you were doing this as a favor, didn't you? I mean, basically, you weren't the attorney of record.
I never became the attorney of record in this case.
And he knew that.
Correct.
Okay. And so he knew at the time from your conversations that this, when he made, or at least at the time of the 4-hour sale, there was no indication at all that you were representing Mrs. Broderick, was there?
Well, other than the fact that I came down and negotiated the deal for a few days earlier.
Well, during that negotiation, you talked to him about the fact that you had requested a retainer, hadn't you?
I don't know if it occurred during that meeting, but I certainly had mentioned it earlier.
And you were never forwarded a retainer, were you?
No.
And you talked to Mrs. Broderick that is at least a common thing that happens, decide whether the money retains the other attorney, and then it's decided later on in the divorce.
Well, the retainer agreement that she signed called for a retainer, which was never paid.
Okay. But you talked to her about the fact that the normal course is for the husband to pay the retainer, and then if the court decides some point later as to who's going to pay it.
I don't think there's a normal course, but where you have someone making significant income, or there was some significant amounts of community properties in the bank, cash. Those are normally first used for the payment of fees, and if there's no money available, then you go to the high earner.
Okay. And you told her that you would be able to get that money from Mr. Broderick. It was your belief anyways.
I thought I would be able to,
Okay. And that was not forthcoming at the time of this, was it?
not on a voluntary basis.
Okay. And at the time of the sale of this negotiation, there was talk about your fee coming out of the Coral Reef proceeds, wasn't there?
I don't recall, but it would have been an appropriate subject of conversation.
You don't remember calling Mrs. Broderick about the 4-hour notice, do you?
I don't recall one way or the other.
Okay, well, you keep, obviously, a 4-hour sale of a community asset of this amount is a fairly substantial transaction for a party, is it not?
Depends on the circumstances.
Did you make any note of calling Mrs. Broderick? Did you told her about it?
I did not find any notes among my notes.
Okay, and did you find any notes at all that, did you find among your notes any note that you had talked to Mr. Ashworth?
No,
And I take it you have no recollection of telling Mr. Ashworth, I'm not attorney of record, or calling him back saying, I'm not attorney of record, this is not my matter.
no, that I wouldn't have done. That I wouldn't have done.
Now, I'm assuming that, and a 4-hour notice means that if he calls your office at 1:30 in the afternoon and leaves a message, whether you get it or not, the hearing can take place that day, does it not?
Objection, as soon as the fact's not in evidence. Is that what it means?
It can.
And I take it that being in Beverly Hills, even under the best circumstance, it's almost impossible for you to get from Beverly Hills in the afternoon, going through Los Angeles down to San Diego in 4 hours, is it not?
No, if you were serious about the 4 hours, yes, it would be very different.
You weren't called the day before, were you, about that? No recollection?
I don't have any recollection.
No recollection of being called that morning to be given notice?
No, I have no independent recollection.
And you don't have any recollection of talking to Mrs. Broderick where she had any reaction at all, is that correct? To a 4-hour
Not to the 4-hour notice. I recall her reaction when I first mentioned it to her, but not in connection with the 4-hour notice.
Now, there was time, she expressed some reluctance about selling a house at some point, didn't she? I mean, at least she threw up, she had some reluctance and kept throwing up different roadblocks.
Oh, obviously. She wouldn't sign the stipulation.
Did she tell you at any time that at least that was the family home?
She did.
And that it was very difficult for her to sell the family home where the children were raised?
I'm sure she mentioned that early on.
You indicated that there was 18,500 that was agreed upon, but the issue was reserved. In other words, you didn't get half of the insurance money because Mr. Broderick said, well, I'll only give it to you now, but I'm going to fight for it later in court.
The stipulation, as I recall reading it, said $7,500, which would be half of $15,000, would be finished, and we fight over the.
So we've been saying that this guy is looks like the Bueller guy. But I see what you guys are saying about the other guy. They both win. Yet the judge is always in the same position, leaned back against his chair, wishing he had made different choices in life. Also, it looks like the mannequin's made up a little bit. She still had her back to him, but they're standing by each other today. And just so you know, Haley Mouse isn't here right now, so she would think Spirit was talking to her again. But the woman's on the phone, if you didn't see her. So she's the one that's talking. Oh my goodness. And also I've been sitting here listening going, I bet attorneys hate. Oh, there she is. I say your name and you appear. Wow. Look, Haley. It definitely was Spirit. That was a little crazy. I bet attorneys hate having to have attorneys on the stand. Yeah, Holly, he absolutely looks like him. It is crazy. The spirit told you I was going to talk about you. Hey, Spirit, that was our secret. Oh my goodness. Alrighty, that was funny. Great timing, Haley.
Other 11 or 11,000, I guess it would at a later date.
Had you had any knowledge of previous offers on the home 2 or 3 years earlier than that as to potential sale price?
No.
Objection irrelevant.
Overall, the answer stands.
Did you make any attempt to find out whether it appeared to be a reasonable price?
Nothing other than my conversations with Mrs. Broderick.
Did she show you any agreements from 2 years earlier showing a sale price that was turned down by Mr. Broderick for any amount, for the same amount?
If that sounds familiar.
And did she at least give some indication that she had some suspicion about the sale?
I don't recall that. Suspicion in terms of that it wasn't an arm's length transaction, or that was some buyer put up by Mr. Broderick or something like that?
Was there any of that?
No, I didn't hear any of that.
Okay. And anything about why the price or who it was or what was going on with the home, why it was being sold then?
No, there was an offer that came in, I think, a month before in December. We had a significant amount of correspondence concerning that offer. That was a month or 6 weeks before the meeting.
I know.
Good, Rick?
Did this offer, what was it, 2 or 3 weeks before you were talking about?
It was early December of 1985.
And that offer fell through as well?
That offer fell through
Why was that?
because Mrs. Broderick wouldn't agree to the sale.
The defendant wouldn't agree to the sale?
Yeah.
Your Honor, I have two documents here. One is People's Proposed Exhibits, struck at a 3-page letter on Jaffe and Clemens letterhead, signed January 9th, 1986. Would that be labeled People's Exhibit 48?
So marked.
And another 2-page document on Jaffe and Clemens letterhead entitled Authority to Represent and Fee and Cost Agreement, dated on page 2, October 29, 1985. Could that be labeled People's Exhibit 49?
So marked.
Now, I will show you People's Exhibit 48. Are you familiar with that document, sir?
Yes.
There's some highlight on the first page that I assume was not on the document when it was executed.
Yes, that's correct. Nor was the January 13, 1986 on the document.
Okay, and for the record, you're talking about a date stamp up in the upper right-hand corner of the first page.
Yes.
What is that document?
It's a letter I wrote to Mr. Ashworth. Setting forth Mrs. Broderick's reasons for not wanting to sell the Coral Reef property. The $47,000 of alleged community funds that went into the property. That he was going to be charged with the $47,000.
Who's going to be charged?
Mr. Broderick, that's what we were asking for.
No, I don't have an objection to reading the letter.
I'm going to go into this, Your Honor.
The best evidence speaks for itself unless you want to ask him a question from.
Okay. Was this letter written before or after the aborted negotiations where the plaintiff refused to agree?
I think that meeting was January 31st, so this is 2 or 3 weeks earlier than that.
And this letter does it not show?
Holly, you just made me feel old. The 80s. Of course, I mean, I was not born in the 80s. I was born before that. But yeah, I had some of the 80s fashion. Yes, and the dresses were statement makers. The shoulder pads would poke your eye out, and yes, the court reporter. She has some dresses. Oh my goodness. Oh, 77. Okay, so I was 73, so we're not that far apart, but I know what you're talking about. Okay. Makes me feel better. Your mom had some crackers too. Silky numbers. I wish I could read that with your accent, Haley. Silky numbers with sequins down the front and shoulder pads. Very Dynasty. Oh, yes. Dynasty. I felt sorry for those stunt actors who always had to go into the pool with the dresses, the big gowns. 1971. Ha! Flash man, look at that. Mr. 2000. Can we please say something about the decanter? Well, he's already been in it. I washed him for a glass. I was waiting. Gabby didn't comment, so I was like, where's Gabby at? She's not watching. He's picking up the decanter. You can and did, whoops. You can and did read that in Haley's voice. Hello, Adair. How are you? Is that almost time for some pickleball? I know, we're going to lose you. So, I won't pause it again unless you guys tell me to. But when the camera pans back over to the mannequins, one, who keeps moving the mannequins? But two, there's something weird with the male mannequin. I think it may just be the way something is positioned. or he's, I don't know. You guys, if you see it, you let me know. I haven't been able to get a good look at it yet. I'm just telling you, there's something weird. Also, I did want to mention, so Dan, when they mentioned Larry, I think his name was Larry Broderick. I did see that Dan allegedly had loaned his brother $450,000 before he had filed for divorce. There was 3 transactions that I don't remember exactly from what account, but I do remember that one. And there was one, I think, for maybe like $170,000, and then another one for, I don't know, several tens of thousands of dollars. And then I do remember the $450,000 loan to his brother. So that's what they were talking about. And I'm sure that we will, Flash fan. I'm sure at some point they'll get into if he did that or not.
Shows clearly Mrs. Broderick's position that she's entitled to 1/2 of the sale of the residence plus an additional $23,500 out of Daniel Broderick's half.
I'm still going to object to it. It's irrelevant what his correspondence with Mr. Ashworth was.
It's not as big.
Overruled.
Well,
It's not irrelevant. Go ahead.
that there was $47,000 of community funds not well spent on the residence.
Okay. And that would translate to the defendant's.
Half of that she would be entitled to $23,500.
So in this letter, you are demanding on her behalf that she get half the proceeds plus $23,500.
Actually, I asked for the whole $47,000, and that would come out in the equalizing payment later. And there's a whole provision here as to what would happen at trial, that this is without prejudice, et cetera.
Can you tell us, though, what that letter states so far as the defendant's demand prior to the negotiation for that sale?
Object, best evidence.
No, best evidence is has been entered.
Your Honor, he wrote the letter, and I think he
He testified the demand was for half the proceeds plus $47,000.
That's what it says.
Okay.
It's asked and answered.
Is this letter the result of your conversation with the defendant? These were her personal demands?
Yes.
Did she ever say that she wouldn't part with the Coral Reef residence because it was a family residence?
No, it's not reflected in this letter.
In fact, she wasn't living in Coral Reef at that time, was she?
No, she was living in what she had complained was an uninhabitable piece of property.
That was the La Jolla Shores Calle de Cielo residence?
Yes.
And did she ever say that she was going to go back to the Coral Reef residence if she wished to go back and live there?
No, that was never an issue.
Now, I handed you People's Exhibit 49. Are you familiar with that 2-page document?
This was our standard retainer agreement that we used by the office in 85.
And who was retaining you in that particular document?
Mrs. Broderick,
Did she sign that document?
she did.
And when you negotiated the sale price of the Coral Reef residence, you were acting as her legal representative in that transaction?
This retainer agreement said that $10,000 was payable concurrently with the acceptance of this agreement. It was never paid. So I was not here. I was in a funny position. I'd never gotten the retainer, which had been agreed upon, but I was acting for Mrs. Broderick. And as the letter indicated, I was foot dragging, hoping that somebody from San Diego County would get involved in the case, because it's very expensive to travel from Los Angeles down to San Diego, et cetera, et cetera.
But I assume you weren't acting as a disinterested party in these negotiations. You were trying to act in her best interest. Would that be fair to say?
Yes.
And in terms of the payment of your retainer, it's correct that the defendant would receive, if she had agreed to that sale of the house, half of the sale half the sale price of $375,000,
I think it was 3.25,
$325,000,
less whatever mortgage existed against the property, less sales cost.
and also the $18,500.
She would get the additional 18.5.
And it was your expectation that the defendant then would have given you your $10,000 retainer out of those proceeds that you would have had?
I didn't have an expectation. I expected it, in this case, from someone.
Assuming that Daniel Broderick did not pay your retainer, are there other ways that you normally can get your retainer paid in these situations?
Yes, you can seek a court order for the payment of fees and costs
Have you done that in the past
many times,
and been successful?
many times.
And that merely means the court goes into the community assets and takes community assets and pays you.
Or the higher earning spouse is ordered to pay, or sometimes the lower earnings. Well, no, you can't get a fee. Can't get a fee order against your own client under the law, but you can get an order against the other side.
So either one of the spouses pays you or it comes out of the community assets. Is that fair to say?
Normally,
And later, when the divorce judgment is rendered, the court sorts it out and makes sure that the appropriate party is ultimately charged for your fee. Is that correct?
sometimes if it's paid from the community, it's normally done without prejudice to a court making a later allocation.
It's natural.
If the other party is ordered to make that payment at an early hearing, no, then that's the order. It doesn't get resorted later.
In either event, those two possibilities could have happened in this case.
Yes.
On the sale of the house, I take it the reason you came down is that there was no way to stop the sale. Would that be correct?
I didn't think so.
And that was because it was a reasonable sale?
Your Honor, objection, he doesn't even know if he got notice.
Your Honor, the defense attorney was on in this area.
Sustained, that's the last question on it. Go ahead.
Do you know the reputation of Daniel's attorney at that time, Thomas Ashworth?
Yes.
What is that reputation?
I've known him for a long time. He was one of the top family lawyers in San Diego.
What about his integrity?
I think it's, and that's when I say, would he have given me more time on the 4 hours? If I'd called him, I think he would have. We worked well together on a lot of other things. There were other proceedings pending. There was a contempt before I wrote this letter that he indicated if we resolved certain things, it would go away. So I had no trouble working with Tom Ashford.
Or for that matter, the sale of the house as it was accomplished?
I'm sorry, I didn't know anything about the fact that the house was ultimately ordered sold, that there was a court order, or that the house was sold until much later.
But you're not saying that, as a matter of fact, that Attorney Ashford did not call you, just don't have any recollection of that?
I just don't have any recollection. I get many calls every day. That's nothing I would remember.
And assuming it was sold on that date, you didn't see that as an unreasonable procedure?
No, because I thought we had it resolved when I was down there.
Thank you. Nothing further.
Recross.
Sir, would it change your opinion about Judge Ashworth if you knew that he was sued?
Objection, Your Honor, he's not making it.
He asked an opinion about the man's
Your
reputation.
Honor, may we approach sidebar?
Yes, come on up.
Yeah, you aware that Mr. Ashworth was
I
sued?
believe the way you do that is have you heard, Mr. Gerwig?
Have you heard that Mr. Ashworth was sued and settled the case for defrauding a client?
In
No.
excess of $1 million.
I had not.
Okay. And I take it you didn't take that into account in your opinion of Mr. Ashworth?
That's correct.
Okay. You're aware of state bar rules on professional conduct, aren't you?
Yes.
Were you aware that Mr. Ashworth was convicted of 2 drunk drivings?
No.
Were you aware that Mr.
I
Ashworth,
believe these should be have you heard.
oh, I'm sorry, when an attorney is involved in litigation as an attorney, he doesn't usually get involved as a judge, does he?
I don't think he can.
Have you heard that Mr. Ashworth had his name signed in orders in this case?
Objection, that's not correct, Your Honor.
So have you heard?
I don't know. I don't know. I have not heard.
The, had you heard that, that at the time that you were not receiving money for this case, that another lawyer was retained after writing a letter to Mr. Broderick about how best to handle his own client?
Objection, assumes facts not in evidence, not relevant.
Sustained.
Sir, the, you indicated that when you talked about fees and who pays the fees, one of the things the court looks at is which spouse is earning, has the highest earning capabilities. Is that correct?
Yes, in a court proceeding.
At that time, did you know that Mr. Broderick was earning about somewhere in almost close to $1 million a year?
Objection, Your Honor, this is irrelevant.
Sustained.
Well, when the district attorney asked you about the fee agreement, he asked you about how that determination is, how they make that determination.
How
Remember
a court would make that determination.
Yes.
Yes.
Okay, and at that point in time, you knew that Mrs. Broderick was earning no money, didn't you?
Objection, irrelevant.
Sustained.
Did you talk to Mrs. Broderick about the fee arrangement, who was gonna pay?
Objection, Your
Oh my gosh. Hey, Petaltown, that's what I said, but I'm trying to figure out what is that on the mannequin? I don't know what that is. I'm scared that it's in a weird place and that I don't know. Yeah, that's my fear. That's my fear, Petaltown. Yes, little one. She is giving him the cold shoulder, but she's moved closer. Yesterday and the day before, she was not that close. Yeah, but why is it? All right, I'm not asking any more questions about it. It's weird, and I don't remember it being there yesterday or the day before. It's like he got a tumor overnight. Also, where's his other hand? Don't answer. I was kidding.
Honor, this whole issue is
Well,
irrelevant.
that's relevant. Overruled.
Yes.
And did you talk to her about the normal course of how it's paid? And what might happen in this case?
Yes.
And you know, normally, if you have a belief that you're not going to be paid by the other spouse, you would require the money up front before you got involved in San Diego, wouldn't you?
Yes.
Okay? And in this case, it was your belief that you could get a court order for Mr. Broderick to pay.
I never was, if I had to, if the only way I could get a retainer in this case was by going for a court order, I wouldn't have gotten into the case. It would have had to have been paid, in this case, on a voluntary basis by either Mr. or Mrs. Broderick.
And I take it that you had at least told Mrs. Broderick that you would request those funds.
Yes.
And the reason you took it is you believe they would be forthcoming.
I assumed they would be forthcoming from someone.
Okay. Well, you believe you made the request of Mr. Broderick through his attorney, didn't you?
I did.
And you believe they would be forthcoming from him.
I hoped.
And at some point in time, did you talk to Mr. Ashworth about having to go to
the legal community to make sure that Mrs. Broderick's rights were protected?
Yes. I think I wrote him to that effect.
At least at some point in time, you had some concerns about the way the case was proceeding or the way he was handling it.
Who's he?
Mr. Ashworth.
I got brought into the case over the months at a very random method. I think I got concerned when, I think maybe 6 months later, and after I really had withdrawn, there was a notice of default sent out on behalf of Mrs. Broderick. Mrs. Broderick hadn't filed the response to the petition, which had been served on her in September or October.
And then you wrote, did you write this letter showing you defense and your honor, and that's on Mr. Jaffe's stationery?
Is there a date on there?
It's
September 23rd, 1986.
Thank you.
Yes, I wrote that.
I have no further questions at this time.
Mr. Burkhoff.
Once again, Mr. Jaffe, did you see anything in any way improper about the sale of the Coral Reef residence? The way it was handled, anything?
I did.
You're bringing to bear your 23 years as a family law practitioner and making that assessment?
Yes, I thought the deal that we had worked out on the 31st of January was the appropriate thing to do in that case at that time.
And you had what, a $5,000 or $10,000 retainer that had to be paid?
There was a $10,000 retainer that was to be paid.
And I think you stated that you assumed that these funds were going to be forthcoming. I got your language.
I hoped.
Okay. Did you know exactly where they were going to be coming out of?
No.
Did you assume it might be reasonable that they'd be coming out of the sale of the house, that tenants share those proceeds?
It wasn't, it didn't make any difference to me where they came out at that point. I was into the case just in time alone, $5,000 or $6,000, and hadn't received any money.
Would that have been unusual, though, to have the defendant take the money she got from the sale of the house and give it to you if you're
You
retained?
know, often the monies will come out of a community asset or a community bank account, pending later determination as to who would be charged with those funds.
And who was it that retained you, Daniel Broderick or the defendant here?
Mrs. Broderick was the client.
You never had any conversations with Daniel Broderick about you getting retained for the defendant, did you?
You know, other than the, I think in that previously marked letter, I had sent Mr. Ashworth a copy of the retainer agreement that Mrs. Broderick had signed in October, and told him again that I would be involved in the case if someone would pay me my retainer.
Now, when you heard about Attorney Ashford taking the defendant's default, where'd you get that information?
I was hearing from Mrs. Broderick every 2 or 3 months on a random phone call basis. I didn't know what was going on with the legal proceeding, if anything, in California, in San Diego. But since I felt that I was peripherally involved, that I was just nervous about being even peripherally involved in the case and not knowing what was going on because I didn't hear from anybody or anything. So I had my paralegal check the court file, the San Diego court file, to find out what was going on in the case, if anything. And she reported back to me that there'd been a notice of default taken according to this letter, this last exhibit introduced by counsel, that a notice of default had been sent in July.
Do you know what the default that referred to, whether it was just a dissolution of the marital relationship or whether it had to do with actual marital
I
property?
don't think I ever saw the document itself. To this date, I don't think I have.
Is it unusual to have a bifurcation of the divorce process where couples get divorced? In other words, they're no longer husband and wife, but you still have to sort out who gets what in terms of property.
Yeah, but that's usually done by court order or stipulation. It's not done normally by just one side defaulting the other and only proceeding on that part of the case. That would be highly unusual.
Now, defense counsel said something about you asking the legal community to protect the defendant's interests.
Yes, that's what the letter said.
The letter that he showed you,
Yes.
and that was because that you thought the defendant was acting unreasonably in this divorce proceeding.
With all of the allegations and conduct, I think the letter really speaks for itself. I didn't think she was, because of her conduct, she was going to give a very hard time getting a lawyer, San Diego or elsewhere, or me. And it was my suggestion, I don't know if it was in this letter or the letter that you showed, that I thought a guardian ad litem should be appointed for Mrs. Broderick.
That was because she was unreasonable in your.
No, I didn't know at that time if she could come to grips and make a decision. And I thought somebody ought, and particularly in light of the bizarre conduct that I've been hearing about over really the course of a year. I thought perhaps some of the legal system ought to step in and perhaps appoint a guardian ad litem for her to make these kind of decisions for her.
Because of her unreasonable conduct
Because of
or bizarre conduct.
bizarre conduct.
In fact, didn't you cease representation largely because she wouldn't follow your advice and she was an unreasonable client?
No objection.
Sustained, rephrase it.
Why did you cease representation of the defendant?
A number of reasons. She obviously wouldn't follow my advice, and I didn't think she would follow anybody's advice. Her conduct would just have us in court all the time, and I just think it's non-productive to run up thousands and thousands of dollars in legal fees defending contempts and those types of proceedings. I just don't think it's productive time, and that's not in my expertise. We handle large asset divorce cases, and my expertise is in dividing large estates. And I just thought it would be a horrible waste of time for me to have to keep coming down to San Diego to deal with all of these peripheral matters, which never got to the heart of the issue. And clearly, and I also wasn't getting paid. So a combination of those three factors, I essentially said, I really don't need this.
Had you been paid the $10,000 retainer, would you still want to remain representing the defendant?
Your Honor, objection calls for speculation.
Sustained.
Hello, Robin. How are you? Good to see you. Thank you for watching on replay and dropping a like. And yes, my daughter does live a very super happy life now. She just lives in a state that I always tell her wants to unalive her. Everything there. So, but thank you. Thank you for dropping by. I appreciate it. The lawyer asked him, I can't probably read yours. All right. Oh, sorry for the bad pause there. But I think that's how he's feeling right now. This testimony is, oh, Betty's daughter. I thought you said my daughter. Well, she is too. I need to read a little better. Sorry. I was wondering how you did a deep dive. Never mind. It's been it's okie doke. Gabby is being naughty. This guy's testimony right now is not good for Betty at all. He's talking about why he didn't want to represent her. One, he didn't get paid. And two, she was going to rack up this huge bill because she was being unreasonable about everything. It's not. Oh, sorry. Hey, little one, reading is hard. It's what it is. I have no excuses. Okay, back to the guy that's thrilled.
If you had received a retainer with the money itself have caused you to stay in the case.
No, our objection calls for speculation.
It's not speculation.
No, whole rules, may answer that.
I don't know, to be honest with you. If somebody was paying my fee on a regular basis to go through what the process was in the Broderick divorce case, and if I thought I was being productive and helpful, I would have stayed in if I had any type of client control.
Did you in this case?
Well, I wasn't in it long enough. I mean, my first major venture into the case was to have a stip drawn up, divide the house proceeds, to get her essentially more than half based on the deal that we talked about before, and then she didn't accept that, and I thought that's what I had come down for, and I thought that's what was agreeable, and that's what was rational. And nothing happened on that occasion, and there was some other conduct that happened after the court order or shortly after that, and it was just too difficult a situation.
Because the time is coming.
Yeah, clearly.
Thank you.
Sure.
Sir, when you were asked about involved, you clearly indicated in the letter that you thought that the only way this case morally and ethically could go forward was Mr. Ashworth's office making sure that she had some representation there, even if it was by court order, rather than just going in and defaulting. Isn't that what you said?
She had to have competent legal representation in this case, but it's difficult when you have a very difficult client.
Sir, just if you could listen to my question.
I'm sorry.
My question was, didn't you write in the letter that not that the court system, but Mr. Ashworth, you felt had an obligation, if this case was to ethically and morally move forward, was to go to the court if there was no lawyer and make sure that somebody was appointed?
Either somebody was.
Objection, excuse me, sir, the letter speaks for itself. The counsel's objection.
Well, just staying, you can show him the letter and ask him a question from him. We referring to the defendant's hand?
Yes.
You want me to read that paragraph?
Just read it to yourself.
I'll read it to you, sir.
Yes.
And it was your feeling, not that the court system, but that Mr. Ashworth's office had a duty for it to ethically and morally move forward, is that someone be appointed
for her so that there would be someone in court to protect her interests.
An objection, letter speaks for itself, Judge.
Well, overruled.
I suggested that a guardian ad litem be appointed for Mrs. Broderick. The guardian ad litem would then retain counsel and would have legal authority to retain counsel.
What's up, Iris? How are you doing? I hope you're not roasting down there in Texas. I hear parts of it has a heat wave. Ronnie has a heat wave. Zach has a heat wave. Carmen says she does not yet. Hope you're doing well. It's good to see you.
As I advised Mr. Ashworth that I didn't think Mrs. Broderick understood that how her conduct would affect the entire divorce proceeding.
Are you aware of Mr. Broderick's conduct?
Only to the extent certain pleadings showed up in my file.
The, during the time that, when you first talked to Mrs. Broderick about the fee, apparently, at least you felt that this was a case that you would take, given if in fact you were paid. Is that correct?
Yes.
Okay. And I take it that, as you've mentioned before, if you took it without money from Mrs. Broderick because you believed you would be paid from some source in San Diego. Mr. Broderick.
Objection, that's not his testimony.
No. Sustained. I think we've gone up into the fee arrangement, Mr. Early.
Well, the problems then that developed with Mrs. Broderick were problems after someone refused to pay the fee. Wasn't that correct?
Objection, that's not his testimony.
Overruled. You can answer that.
No, it's not correct.
Okay. So you had misgivings about this case at the very time the fee agreement was signed without having any money up front. Is that correct?
My miss.
Paultown, I don't know what happened to your membership. I'm sorry, but thank you for rejoining. Hopefully you get your months back. You should. I've had people that were gone for a while, then came back. Ugh. Talking is hard for me today, so is reading. So, hey, Flash fan. I control nothing. Yeah, that's true. That is true. I blame your bank. But yeah, I don't know. Because I swore you had it yesterday. Weird.
Misgivings were not in October when the fee agreement was signed.
Okay.
My misgivings came up in November and December.
Okay. But in October, you didn't have any misgivings.
No, not at all.
And I'm sure that you communicated with Mrs. Broderick that you were told by Mr. Ashworth that Mr. Broderick was not going to be paying your fee, were you not?
Nobody ever advised me.
Well, you told Mrs. Broderick that you had made the request and that you were never paid, didn't you?
Yes.
And was she upset about that at all?
Objection, irrelevant.
Sustained.
I have no further questions.
Any further, Mr. Burkhoff?
Yes.
How long are you going to be until after the recess?
2 minutes?
Go ahead.
I have a 2-page document. It's a letter on Mitchell, Ashworth, Keeney, Berry, and Pike, stationery dated October 25th, 1989. We have that labeled People's Exhibit 50.
So marked.
Are you familiar with People's Exhibit 50?
Yes.
Is that the letter that Tom Ashworth wrote in response to you, to your letter that you identified earlier with the defense attorney. It was good. Thank you. Did you know whether or not the defendant had legal representation at the time that that you wrote the letter the defense attorney showed you? Your Honor, objection calls for hearsay and speculation.
Well, just do you know, yes or no?
Yes.
Overall.
Through personal knowledge, he knows.
He said he did.
But she represented.
Yes. Police.
So you're an attorney, aren't you? Aren't you?
Still.
Do you know what personal knowledge means?
Yes.
Okay. Personal knowledge is not what's.
Objection argumentative.
Sustained.
Did you know from any other source than the fact that somebody might have told you something? Your source of knowing whether she had a lawyer, was that from Mr. Ashworth?
No.
Okay. And was that, at the time of that letter, you already had some personal knowledge?
Yes.
Okay, and who was that from?
Mrs. Broderick.
Okay, and she told you that she had a lawyer at the time that you wrote your letter?
That she had hired someone, yes.
Okay. And when did this conversation take
I
place?
don't know if it's a conversation, I think, either it's a conversation or she wrote it to me in a note.
But you wrote a letter September 23rd saying she needed a lawyer, is that correct?
She needed I don't want to sound patronizing, she needed a heavyweight lawyer.
So you had some doubts about the lawyer she had,
Yes, she did.
and that's the reason you were writing this letter?
It was, yes, that was one of the reasons.
I have no question. Further, Your Honor.
Witness be excused?
Yes.
Surely.
Subject to recall. Subject to recall.
All right. Thank you very much, Mr. Jaffe.
Subject to recall. That is it for that. There we go. I don't know what I'm doing today. Little one. I don't know. I don't think he was making a fat joke, but maybe. So memberships are just a way to support the channel and help me. I am overdue to do a members only stream. So I haven't done one of those. I was thinking about that today, that I hadn't done one of those in a while. But that's what those help. They're basically to support me. Hey, Nidawow. How are you? I don't know what Rule 29 is, but I'm going to assume it wasn't good. All right, so let me do this because I want to show you this AI thing where this victim, for lack of he's a victim, but he was allowed to give his victim impact statement through AI in court in Arizona, and it's very it's strange. I don't know what I think about it because it's not him. Oh, Iris, you were the one I was thinking of. Like, I need to have you on to do a members only stream. So, absolutely. And it is not hard to derail me at all. Little one, I think it's 99 cents for the lowest one a month. I think $1.99 and for the middle one and $4.99 for the highest one. Oh, Rule 29 you said. It's a motion the defense attorneys make after the state rests and then again after they rest, alleging the state didn't meet their burden and they got it? Wow. Wow. You'll come on topless. No, no bottomless. All right, are you going to buffer or are you going to play Julie Grant? Not my favorite. All right, let me see what this is going to do. I don't know if I need this boosted or not. So I do have it boosted. So if I need to turn it down, let me know.
So what if a victim could speak from the grave? Well, this morning, our spotlight shines on new AI technology that allows for just that. Christopher Pelkey was the victim of a road rage incident that took his life, sadly. But even though Christopher was killed, he still had a voice in his case.
Hello. Just to be clear for everyone seeing this, I am a version of Chris Pelkey recreated through AI that uses my picture and my voice profile. I was able to be digitally regenerated to share with you today. But here is insight into who I actually was in real life. Take a look.
Hi, I'm Chris Pelkey. I served with the United States Army in the infantry. I'm from upstate New York.
So as you can see from my video, I recorded in 2021. This here is a true representation of who I was, you know, not how the courtroom portrayed me. So I would like to make my own impact statement. So, hello, everybody. Thank you so much for being here today. It means a lot. And for everyone who has supported my family and loved ones through 3.5 years and 2 trials, I wish I could be with you all today. To Your Honor, Judge Lang, thank you for making yourself available to see this case to the end, especially when the rescheduled trial conflicted with your daughter's spring break. To Gabriel Horcasitas, the man who shot me. It is a shame we encountered each other that day in those circumstances. In another life, we probably could have been friends. I believe in forgiveness and in God who forgives. I always have, and I still do. Thank you to everyone for being here. It means more than you know. Well, I'm going to go fishing now. Love you all. See you on the other side.
My goodness. Can you?
I can't listen to her, but is that not just weird? Yeah, yes. I can copy. That's exactly. Well, I would, if you and Gabby were singing the Bardian song, that would be hilarious. Yes, it is real, and then it's pausing. Those pauses were weird. I don't like it. I don't like it. It's, yep, love you all. Oh, this is how Jesus is coming back. You can see it's not actually real, but it's too close. It is real. Or it isn't. I give up on talking today. Oh, Flash fan, that's a hard one to answer. That's what I say. We don't know what he would really say, so they get to put in what they want him to say. I don't know. That is just so weird. You just need AI to get you out of paying taxes. Yes, you are real, Gabby. I think. I've never seen you in person. Not in real life. Just YouTube life. Streaming life. It does make you just wonder where this is going to go, where it's going to stop. I think if people try to use it too much, there'll be a lot of legal challenges to it. And I think there probably should be. Just because, like when Baker was here earlier, he said it's not them. They're not making the statement. It shouldn't be allowed. I agree. Unfortunately, Iris, you are right. Aches and pains will tell you if you're real. Yes, I remember when Adair thought you were a robot, Gabby. Oh, that's hilarious. I know. And Flashman, I had to read that twice too because I thought it said AJ. And I thought earlier when Baker said something about AI, when he was quoting me when I said AI freaks me out, I thought he said AJ freaks me out. I was like, what the heck did I do? Yeah. Adair. Oh my goodness. I just don't know. I don't know about that. It's very strange. And I was reading what they had written underneath it, and it said that it the judge said it influenced him, and he gave the guy a year longer than they were even asking for. They were asking for 9.5 years. The judge gave him 10.5 years. He sentenced the guy to 10.5 years. So even more crazy. Like he let it influence him. So I have no idea. I don't know. But it was weird. It's weird. And when I saw the story today, I thought this can't be like, what is this? Then I realized how creepy it was. So I wanted you guys to be creeped out with me because it's only fair. He only got an extra year by he got an extra year by Star Trek hologram. Oh my gosh. Oh, that is so true. I didn't think about it that way. I mean, I don't know the case. I don't know. I didn't read on to see like what happened between the two. Um, but yeah. No, we don't need AIJJ. No, no. I don't know what I did to complete your day. You're welcome. I don't know. So, remember tomorrow I will not be here, which means I apologize. I might see if Carmen and maybe Miss Gabby can cover for me a week from Wednesday if Carmen's off work. Because otherwise that's going to mean I miss 3 Wednesdays in a row. But tomorrow's my dad's 84th birthday and we are taking him out to dinner. So I apologize for not being here. And then the next week will be my regular dinner with my dad and my brother. So, but Thursday we are going to, my plan is I will have to keep an eye on it to see how it goes, to see if it's, yes, Gabby, to see if, one, if they stream it, and two, how long it is. But the boat club crashed lady will be sentenced on Thursday. And I do plan to watch that Thursday night. See you, little one. Or is that you, little one? Thank you. Thank you for wishing my dad happy birthday. So my plan is to watch that sentencing. If it's not something, if I see it kind of during the day or if they just don't stream it, we'll continue on with the Betty Broderick trial. Her daughter, that none of you like, will be back on the stand when we resume. We actually have, I think, 2 more parts with her. So I thought, yesterday, I swore the defense said they didn't have any more questions. So I guess I was wrong. And they have lots more questions. So she's going to be there for a while. And then we're just going to start getting some of the random friends and people like that coming in, which will still just give us, they're way more, to me, more interesting than the law enforcement people in this case, because they're giving us a glimpse into what life was like as Betty, like with Betty and with Dan. I don't think either one of them were angels by any means. So I don't know. I am not ghosting you. And yes, I know what ghosting is. I'm not a Massachusetts State Trooper. Also, Gabby, I was watching The Glare and Bob Motta from the Defense Diaries today, and guess what? I think it was The Glare, because I wasn't watching, I guess I was listening. He called Worcester Worcester, and I felt vindicated. I'm just gonna say. I felt so vindicated. I don't know what trial from 1996 Flash ban, but somebody in the Glares chat corrected him that it was Worcester or Roosta. Sorry, Casperita. Sounds like a drink. Buys AJ flowers a day. Might have a deal there, Puddletown. He never corrected himself, but somebody in chat corrected him, and it was hilarious. It's hilarious. I was like, Worcester? I was like, he must mean, well, I can't say it, because even I have to say Worcester, not, whatever. Whatever. Flashman, 1996. My trial? I didn't have a trial. I don't know. Nope. I was not. I was not. I was considered an adult. Actually, yep, I was considered an adult. I guess I pled out. That's right. That's why I'm not in jail. I served my time. Dang it. Leave me alone. She was a pole dancer night. I was Flash fan. Wow. Whoa. I'm not sure that's you. I think this is AI. Sentenced to being a mom to Carmen. Yep. I was. I was not working the pole. I swear, I wasn't. Yeah, I'm telling him too. Yes, I was dancing with the fishing rod. Hey, I like to fish. I haven't been fishing in a long time. I do not I do not have an onlycorn.com. I was working. Not working. I was working it. Oh my gosh. Okay. I was like, I had to stop myself because I was almost about to say, oh my gosh, you guys. Yeah, that I cannot do. I cannot. I always give my husband a hard time because he can. It's kind of weird. He says he can't, but I'm like, you can more than I can. And it's hilarious. We are. I was not. I was not working in the cornfields. Working it in the cornfields. I did not. Flashman, I'm going to ground you. I never ever said that. I'll let him know. Sings a cornfield spiritual. I'm not sure how that goes. Or if I want to know how that goes. You can still pop, lock, and drop it. It's getting back up. You can't do. You cannot pop, lock, and drop it. And I would not probably also be able to get back up. Oh. North side, or however I said it that one time. I don't even know what that was. Good grief. I was not working in the field. Iris is a party everywhere she goes, and that's why she's fun. It's AJ after party. I don't think you should be here then. Flashman, do we need to card you at the door? You're just on a roll tonight. I know. Wait, where's Flashman? This is AI Flashman. Our Flashman is like this innocent, sweet guy. Like, who is this? What's happening? All right, Metallica. I know I say this all the time, but because I get up early and I'm not really paying attention to the TV. I just have it on mostly for light. But I've been watching old like 80s videos. I can tell you some didn't age well, like Lionel Richie's Hello, Stalker. But then you look at them like some people didn't age very well either. But I can't say anything about Metallica. Yes, Flashman is tired. Wow. I don't know what's happening. That monkey. Puddletown, Iris, and that monkey are going for a ride in the Buick LeSabre. I think that's what Gabby said the attorney on the stand drove, Puddletown. The one you didn't like his hair? I hope Gabby had food today, because if she didn't, Haley, she's drinking on an empty stomach right now. And it's way past 5 o'clock. And that might be why things are so fun. All right. Does anybody have anything else? When you're this tired, who knows what will come out of your mouth? Well, Flashman. It's been interesting. It's been interesting. We won't tell on you. I won't tell on you. I can't help it. If anybody comes in here and sees things or hears things or somebody shares this, I can't help it. I did my other camera came in like right before the stream started, so I haven't had a chance to mess with that yet. So I need to get that hooked up, and hopefully that'll fix my focus problem. Or maybe it'll be worse. I have no idea. It may look the same. But all right, I hear the thunder starting to rumble out there again, and I really, really, really don't want to be on here when if the power goes out, because although Gabby can shut this one down, I can't shut Rumble down, and I just don't want to just leave it up and running because that'd be weird. So I will see you guys all Thursday, 5:30 again. We'll either be doing a sentencing for the boat club lady, or we will continue on with Kim Broderick. I have no idea. And if I find anything else weird or creepy in the between times, we'll do that too, maybe. So y'all have a good rest of your evening. Thanks for hanging out with me. And I will see you guys all next time, or I'll just see you around in people's chat. But enjoy the rest of your night. And Adair, keep the storms over your way, please.